Private Placement Due Diligence Term Sheet and Regulation, prepared by Hebo Jurdi for Finance 139. Private placement memorandums are drawn up when a company decides that it needs more capital. However, PPMs are not so easily put together. It takes a lot of work, a team of attorneys, and plenty of structure to construct a well-written PPM. All this preparation is done for the benefit of both the company who wrote out the PPM and the investor. So why would a company want to raise capital through private placement? A major advantage comes in the form of time and transaction costs. PPOs are not as expensive as an IPO, an initial public offering, because they are avoiding the whole entire deal of going public. Less time is also spent evaluating the company from all angles because there is no need for an underwriter. This does not mean that it is not thoroughly examined before drafting up the term sheet, but there is not as much regulation and scrutiny as there would be in a public offering. Another huge advantage for a company to offer securities through private placement is that it would easily be the fastest way for them to acquire capital from investors. Making sure due diligence procedures are completed fully and thoroughly is extremely essential to the success of a private placement offering. The concept of due diligence is applied when two parties enter into an agreement and both parties have confirmed that all terms in writing are wholeheartedly true. Along with following SEC rules, even though they are not required to, performing precautionary measures can provide for a means for the entire PPO to go off smoothly. In this process, there are rules that the offeror must comply with. Has to be someone who's in charge of making sure all documents needed are collected efficiently and effectively, and that these documents are being used properly within the due diligence process. This person is the main representative of the offeror. They could be an attorney, an advisor, etc. The employees of the company must be aware of the due diligence process and be fully compliant and not stir up any problems later. Due diligence, in a sense, is preventative maintenance in the private placement offering journey. It is used in order to avoid any unnecessary problems, make sure that the business is being conducted in a correct manner, gathers useful information for accurate asset valuation, and it ensures that the transaction between the two parties complies with the rules and regulations. As mentioned before, these rules and regulations are usually similar given to the ones given to companies engaging in public offering through the SEC. Financial due diligence is perhaps the most important part of the entire due diligence process. When financial due diligence takes place, there is analysis done on the proposed transactions in order to minimize risk that could be taken on by the investors. These institutions that are going to potentially invest into these companies doing a PPO want to know exactly what the company plans to do with the funds, which is where the financial due diligence comes into play. On the part of the investor, questions about the objectives of the offer could be asked. Why do you need additional financing and what are your goals? The investor or investors may also want to know what the company will be using the financing for once they have it. When will the proposed closing date be? Valuation and price per share. Who is on the board? How fair and reasonable the stock option price is. A lot of focus goes into this area of the due diligence process. Historical financial statements and predictions on the financial well-being of the firm are also highlighted during this portion of the analysis. The characteristics of financial due diligence are sometimes confused with the auditing procedure. However, auditing only focuses on the company's past financial statements and assesses whether or not the financials are being truthful rather than whether or not they are seen as any risk. The term sheet, also known as the letter of intent in legal jargon, is vital in a private placement memorandum. This document sets forth the terms of agreement between the parties. It is the basis and foundation for the deal and determines the conditions of a deal. Usually the term sheet is non-binding, but it brings a level of good faith between the parties involved, and it works as a bridge to working out the initial negotiation and the end agreement. Due diligence, as well as many other things, are listed on the term sheet. After the terms have been agreed upon, They become the basis for forming the definitive agreement, which is drafted up by an attorney. Offers to sell securities must be registered with the SEC, public offers, or they must meet the qualifications for exemption, which are private offers. Regulation D specifies the rules for exemption from registration requirements, which allows companies not to have to register with the SEC when doing a private placement offer. A Regulation D offering is much more cheaper than the normal SEC registration, which makes it possible for smaller companies to raise capital through PPOs while still being transparent and abiding by the laws. There are various rules outlined through Regulation D, but in terms of PPM, it is important to highlight the exemptions from SEC registration: 504, Rule 505, and Rule 5. Regulation D, Rule 504, exemption of up to $1 million for offers and sales of securities within a year. It does not have to meet the reporting requirements of the Exchange Act of 1934. A company is allowed to sell the securities when it is registered in the states that require publicly filed registrations. All disclosure statements that are authorized by the state have to be delivered. Regulation D, Rule 505, has an exemption of up to $5 million for offers and for sales of securities within a year. There can be up to 35 unaccredited investors, meaning that there can be any investor regardless of income. There are no limitations on how many accredited investors there can be. Securities issued have to be restricted in the sense that investors would not be allowed to sell them for at least 2 years without registration. This is because the securities are not purchased for reselling purposes, but as an investment. Sales of securities are not open to the public. Within 15 days of first sale of the offering, SEC must be notified regarding the transaction, and financial statements must be certified by a third-party independent CPA. If a company other than a limited partnership cannot obtain audited financial statements without reasonable effort or expense, only the company's balance sheet, to be dated within 120 days of the start of the offering, must be audited. Regulation D, Rule 506, has a few similarities to Rule 505. However, the exemption of unlimited amount of money through the offers and sales of securities cannot be sold publicly. Sales of securities are targeted to an unlimited amount of accredited investors and up to 35 unaccredited investors. Investors are not allowed to sell for at least a year without registration. In conclusion, while the private placement memorandum does take less time and less money to draft up than a public offering, there are still plenty of procedures, rules, and regulations that need to be followed. The idea of good faith being established between the company offering securities and the investors gives some structure to what could easily be a disaster. Going through the process of due diligence and then writing out and agreeing on the term sheet enable all parties to have peace of mind and will eliminate future problems brought up since there will not be any discrepancies. The key to making a private placement offering successful is to be just as transparent as you would be in a public offering. Thank you for watching.